Hello, my name is Cesar Pereira. I'm the president of the Chartered Institute of Arbitrators, and it's my pleasure and my honor to welcome you to the second session of CIArb Branch Time. This is a program that CIArb offers in partnership with Arbitration Channel to bring together some of our 44 branches that exist all over the world, joining our almost 18,000 professional members in this organization that has existed for 110 years and is present globally. CIR Branch Time in this edition will bring together two of our most dynamic and most long established branches, which are the London branch and the East Asia branch. As you can see from our lineup, we have a huge representation of different jurisdictions that are part of the CIArb family. And I'm very happy to be here with such distinguished speakers. I'm not going to go over the bios of each one because it would take all the time we have for this session. But I can tell you very briefly that we are joined here by Robert Price, who is the chair of the CIArb London branch, by Wenny Huang, who is the deputy CEO of IBRAM in Hong Kong. Glenda, no, that's difficult. Vencatachellum. You can tell me later if I got close. Glenda is a barrister, a mediator in arbitration counsel based in London. Monica Wang, who is the Secretary General of the CIArb Taiwan chapter, part of the East Asia branch. Sue Kim, also based in London, and a chartered quantity surveyor, quantum expert and adjudicator. And you will see that this is a very important topic, adjudication in many of our jurisdictions. Christopher To, based in Hong Kong, and also an international arbitrator and professor in several of the Hong Kong universities. Shobana Iyer, who is a barrister based in London. Douglas Freeman, who is the chair of the CIArb Japan chapter, also part of the East Asia branch. As I said, you can see that we have a very broad range of jurisdictions and specialists that will be able to share with us knowledge in their practical insights about what's going on right now in many of these jurisdictions. And if we think about what's going on right now in London and in China, we can't avoid thinking about the 2025 English Arbitration Act that just came into force last year, in the 2026 China Arbitration Act, which has just come into force now in March. And so the first topic that we will address is precisely this one, these recent legislative changes that took place in the UK and in China, and that may bring us information for us to have some comparative view and to understand the expectations of the respective arbitral communities with regard to these changes. Later, we will move into some peculiarities and some characteristics of arbitration in Taiwan, of the ADR reforms in Japan, and issues related to mediation, adjudication, and expert witness production, expert evidence production, which our other speakers will address as well. At the end, we'll have some time for Q&A with the audience and for some interaction among the panelists. And so I'm very much looking forward to this opportunity to discuss these topics with our guests here today. So to kick us off, I would like to turn to you, Rob. Please, if you can give us some idea of what's happening in the UK now with the new Arbitration Act. Please, the floor is yours. Thank you.
Thank you very much, Cesar. You can hear me okay? Good, excellent. And let me just start by thanking you for putting together this fantastic initiative. I think it's so great that so many of the branches are going to be teamed up in this format, and that the entire CIArb community and the arbitration community in general can learn from this sort of comparative approach. So thank you for all the organisation and effort that's gone into that in the background. As Cesar said, I'm Robert Price. I am the chair of the CIArb London branch. I'm also a partner at Latham & Watkins in the arbitration team in London. And I'm just going to set the scene very briefly. As Cesar said, we have had some interesting developments last year in a sort of important reform to our arbitration law. At a high level, I think most people will be aware that the UK is a leading arbitration-friendly jurisdiction, and London is consistently ranked as often the top global seat for international disputes for its neutral, expert, and confidential legal environment. The recent changes we have had and this is last year in 2025, have been to make some reforms and amendments to the 1996 Arbitration Act that had been in place since that date. And the process of reform was led by the Law Commission here in England and Wales. And the goal was really to fine-tune the framework of the 1996 Act. The general feeling, I think, was that the 1996 Act worked reasonably well. It supported London as a leading, if not the leading, seat for arbitration. But it had been some time since the issues that underpin the Act had been looked at, and it was time to see whether some things had actually stood the test of time. So there was a wide-ranging consultation, 2 reports produced from 2022 into 2023, and the Act went through Parliament and received royal assent in February last year and came into force in August last year. I'm just going to run through a few key areas where some changes have been made. To my mind, the amendments have been broadly welcomed as a sensible set of conservative proposals in a few areas where clarifications were needed, particularly in a few where there had been some uncertainties that had come out of the case law that had developed since the 1996 Act came into being. So the first area where we've seen a change is in respect of court powers to support arbitration. It's been clarified that Section 44 of the Act, which deals with this, is available against third parties where appropriate. Now, previous case law had suggested that some of the powers under Section 44 were only available as against parties to the arbitration. And this did cause some difficulties if you were looking to get, say, freezing injunctions and other sort of interim relief that you needed to apply against third parties. I think that has been broadly welcomed as a helpful additional tool in the toolbox, and perhaps what was already always intended in the 1996 Act. The next area is the governing law of the arbitration agreement, which I think is a topic that appeals to many real arbitration aficionados. It can also be quite a troubling area that can lead to satellite disputes. And this is one of the concerns that was raised in the consultation about the amendments to the Arbitration Act. And the approach that has now been taken is that where parties have not expressly chosen the law to govern their arbitration agreement, the default law will be the law of the seat. So it would be where you've chosen London as your seat, you get English law to govern the arbitration agreement. Now this displaces the previous case law that pointed in that situation to the law of the contract being the law that governed the arbitration agreement. And the concern that people had about this was that where you had a contract governed by some sort of foreign law, that might come with it some narrower views about matters that could be that were dealt with by the law applicable to the arbitration agreement, raising potentially questions about arbitrability, the validity and scope of the arbitration agreement. And it was felt that these narrower conceptions were not what people bargained for when they chose London as a safe seat of arbitration. There is an exception to this for investor state cases where the arbitration clause derives from a treaty or non-UK legislation, because different considerations apply there. But that is quite an important and welcome change in my view. Next, we have the arbitrator's duty of disclosure. This has been put on a statutory basis and just requires arbitrators to disclose circumstances which might reasonably give rise to justifiable doubts about their impartiality. And that is a duty on appointment, and it's a continuing duty during the proceedings. And it essentially, I think, codifies previous decisions of the UK Supreme Court. After that, we have the Section 67 changes. Now, this is the section that deals with challenges to an arbitral award based on the concept that the tribunal did not have jurisdiction. Previously, under the 1996 Act, the position was that there would be de novo review of the arbitrator's jurisdiction should a party wish to do that. So a full rehearing of all the materials. That has been somewhat curtailed. There was quite a debate on this. Some people taking the view that whilst it might be arbitration friendly to some extent to try and narrow the scope of the ability to challenge an arbitrator's jurisdiction, that is nevertheless a fundamental issue on which the court should have the final say. The position we have now is that the ability to challenge an award on the basis of lack of jurisdiction has been somewhat curtailed. Parties can't advance new grounds or evidence that with reasonable diligence they could have deployed in the arbitration, and evidence that was heard by the tribunal cannot now be reheard by the court unless in the interests of justice. So there is a bit of an escape valve there. I think it really does remain to be seen, and others will have views on this, how this actually changes the picture. In my experience, the courts have always been quite keen to ensure that these sorts of challenges are kept within reasonable bounds. A few other changes we have had in relation to emergency arbitrators that have now expressly been recognised. They didn't really exist when the 1996 Act came into force, and there is now a express provision for summary dismissal of claims and defences that have no real prospect of success. So codifying a power that was probably already there, but hopefully encouraging arbitrators to use it. There are various other things that I think probably don't warrant mention, given there are so many other things to discuss, but there are certainly, or I'll just mention as a final point, things that weren't covered, which some people thought should have been covered. So confidentiality was not codified in any way. It was thought to be too difficult to do that. Third-party funding was not covered. Issues to do with AI were also not covered. But broadly, what we can see is an evolution of the Act, not a revolution. It seems to have been a series of incremental changes that have picked up a few niggling issues, and it has been broadly welcomed by the arbitration community in London and I think globally. Thank you, Cesar.
Thank you, Rob. I think this is really interesting what you said at the end, specifically those things that were not covered, but some people thought they should have been. And do you have any specific opinion about that in terms of whether these are, of course, AI it will always be a contentious issue, and I think we could even have some consensus that it may be too early to put that into a statute. But regarding third-party funding and confidentiality, do you think those are still open issues that should require some statutory solution?
I think they are, and it proved in the consultation, it proved very difficult for people to, I think, achieve consensus around a particular approach. So particularly in relation to confidentiality, I think people do still find the sort of the legal basis for confidentiality as it's developed in the cases, how far it extends, the exceptions, that is still quite contentious. And I think you might take the view that where it is still contentious and needs to develop through the case law, it's perhaps better for it to do that. And I probably subscribe to that view myself. But I do think there could have been something of a case for putting in, a small sort of brief flag as to what the general principles were in the Act, so users could see that. But I think I do sort of generally err on the side that, where it is difficult to set out all the rules, you either set them out very briefly and then you have to look to the case law, or you just don't bother at all because it may be sort of somewhat more confusing. And I think, as you say, it's a statute, and there are obviously arbitral rules, the tribunal's procedural orders that can deal with a lot of these things in any event.
Okay, thank you. Well, we will move on now with Shobana, who is also a CIArb London branch committee member, and she will continue to take us through the English Arbitration Act, these changes to the English Arbitration Act. And Shobana, I'm not sure if you're going to address that, but one point that I would like you to clarify for our audience here is the difference between the English Arbitration Act and the UK Arbitration Act, or the arbitration law that applies to the UK and to Scotland beyond England. Can you just explain that to the audience also, please?
Right. I'm afraid I don't have knowledge of the Scottish background, so I'm a barrister practicing from England and Wales, so I can't really assist.
No, yeah, I think the point is just to for our audience to understand exactly what we are talking about when we talk about the English Arbitration Act. Where does it apply and where does it not apply, right? If we think about
so the English
in general.
Yeah, so the English Arbitration Act applies in England and Wales as well as Northern Ireland. So if it's an arbitration seated in any of those jurisdictions, the English Arbitration Act applies. I'm not sure about what the jurisdiction for the Scottish side of it is, or in that way. But I'm a practicing barrister from, obviously, based here in London. And I specialise mainly in commercial and corporate laws concerning usually intellectual property and technology matters. So you can imagine the kind of issues that will turn up in this area. So yes, I'm also a member of the London Branch Committee and the EU Commission approved list of chair arbitrators for trade disputes. I mean, I do act as counsel and arbitrator. I also do mediations as well, but both in domestic and international arbitrations across a wide range of sectors. And what I'm proposing to do is actually go a little bit more into the kind of powers of the tribunal and the courts in granting interim measures in arbitrations under the Arbitration Act, as it were. Now, if I could just try and get my slides up. Right. So what I'm going to do is to give a brief overview of those of the key provisions, actually. And as Robert went and said, now we've got the courts. It should be actually. Sorry, it's got a mistake. It should be court powers under Section 44, not arbitral powers. It's the court's powers under the arbitration. But let me go on to explain exactly where we're going from. So the Arbitration Act applies, as I mentioned, in England and Wales and Northern Ireland. And in those cases, the Arbitration Act of 1996 provides the following categories of emergency powers, so including automatic powers for the tribunal, which apply unless the parties choose to exclude them, and the court powers that can be exercised in order to assist the arbitral tribunal seated in England and Wales. So in terms of the tribunal powers to make an order for interim relief, that is set out in section 38, and it upholds the principle of party autonomy in arbitrations by first providing that the parties are free to agree these powers, so they're not mandatory powers as such, and they're exercisable by the tribunal for the purposes of and in relation to the proceedings. This will commonly be done by the incorporation, usually of a set of institutional arbitration rules in the arbitration agreement or the parties' agreement where we're doing ad hoc arbitrations. So you'll notice from subsection 2 of 38 that this states that unless the parties agreed, unless otherwise agreed by the parties, the tribunal is vested with the following powers, which are vested, and those powers are listed in subsections 3 to 6. And the first one, obviously, is the idea of the tribunal able to provide the security of costs of arbitration and the discretion of the tribunal to exercise these powers, but it's subject to certain restraints, mainly principally with the fact of the jurisdictional issues that the claimant should be either based in UK in that area. But with regard to and that's restrictive in that way. But then you've got subsection 4, which the tribunal may give directions in relation to any property. When we're talking about any property here, it can also include things like shares. Which as long as the subject matter of the proceedings or has to which any question arises in the proceedings, or which is owned by or in the possession of the party to the proceedings. So you know that this power is slightly narrower than what the court's power is to order interim freezing injunctions under Civil Procedure Rules 25, as it only applies to property which is either the subject matter of the proceedings or to which the question arises in the proceedings and it is owned by or in the possession of the party in the proceedings. So there is a restriction there, and this rule is also much narrower than that comparable rule in Article 17 of UNCITRAL model law. So an order made under this rule where there is a risk that the property, you apply for an order here where there is a risk that the property will in some way be removed or dispersed of by the defendant. Then you have, of course, with regard to subsection 5, you have the tribunal can direct a party or witness to be examined on oath of affirmation and administer the necessary oaths, etc. The tribunal may give directions to a party for the preservation for the purposes of these proceedings of any evidence in his custody, and that's if this is where that if the tribunal is unable to act, for example, if it's not been constituted, the court can act under the court's powers under Section 44. But in practice, what usually happens is when parties agree to arbitrate without incorporating a set of institutional rules, they rarely consider the court's power to order interim measures, and it is therefore rare to see that these have been addressed specifically. The powers granted to a tribunal under Section 38 are limited to directions affecting the parties themselves, and therefore if directions are required in relation to third-party consideration, you need to consider the powers of the court as opposed to the tribunal. So if I can move to the next slide. So the powers of the tribunal, powers of the court itself. We know that this provides the court with certain powers to assist arbitration seated in England and Wales and Northern Ireland. Those powers are vested in the court automatically under under the Arbitration Act, and therefore, unless the parties choose to disapply them, so you still keep that party autonomy there. But usually, I think parties keep this in force, and this is one of the reasons why people choose London as a seat of arbitration, because it's the flexibility of the English courts to actually provide these resources, and you'll find that they don't. They limit their ambit in this area as well. So the court has the same powers for making orders in relation to arbitral proceedings as it is in relation to its own court proceedings. However, those powers are limited to certain matters in the Arbitration Act under subsection 44.2, namely the taking of evidence, the preservation of evidence, and the making of orders in relation to property that is subject to the proceedings or in which the question arises in the proceedings for the inspection, photographing, preservation, custody and detention of the property, or ordering that samples are taken from or in the observation to be made or experiment conducted upon the property. And for that purpose, authorizing any person to enter any premises in the possession or control. So in cases of emergent urgency, section 44.3, and it's got particularly with regard to also the sale of goods and of course the granting of interim injunctions or the appointment of a receiver. So in terms of the urgency, this subsection 3 provides the court with a wide power to make such orders as it thinks necessary for the purpose of preserving evidence or assets. That power would include emergency relief under the granting of injunctions to, but majority of the time when I'm saying about that granting of injunctions, probably it's to do with the substantive injunctions and the preservation of important factors related to that arbitration. So usually you do not apply under section 44 for anti-suit injunction. That usually is done under section 9 of the Arbitration Act and also under the court's normal powers under section 37 of the Senior Courts Act. So while vesting the court with wide powers to assist arbitrations, the 1996 Act knows that it recognizes that the principle of party autonomy in the resolution of disputes, and accordingly section 44 makes it clear that the court interference in arbitral proceedings should be minimized where the case is not an urgent one. So if I just move it to the next slide, sorry. Yeah, so they don't interfere where it's unnecessary to do so. So where the case is not an urgent one, the court may only act on the application of a party to the arbitral proceedings with notice of the application to the other party and the arbitral tribunal, made with either the permission of the tribunal or in agreement in writing with the other party. Right. In all other cases, the court may only act if and to the extent that the arbitral tribunal has no power or is unable for the time being to act effectively. So in general terms, emergency relief in arbitration proceedings are usually only to be ordered once the arbitral tribunal has been constituted. But that leaves a period of time prior to the constitution of the tribunal, and the party may require emergency relief, but find it difficult to obtain relief in arbitrations, even with emergency arbitrations, it depends, where the other party seeks to dispose of assets or move money across jurisdictions before the arbitral tribunal has been constituted. And in such circumstances, parties may consider that the only option is to apply to the national courts for the required relief which is available. Now, we'll just stress about a couple of cases that are coming to. I don't know what those streaks are there, but as I mentioned, the court will only act where it's necessary, and if no tribunal has been formed as such in as they can clearly act if it's required to do so, but there's no other provisions in which that the arbitral tribunal can be constituted, or emergency arbitrator or expedited formation of the tribunal cannot be constituted in time in order to jeopardize the property or the requirement for disassociation of assets. So in Gerald Metals versus SA versus Timmers, the commercial court dismissed an application for a freezing injunction and for the possession of information under Section 44, finding that effective relief was potentially available under the LCIA rules, particularly Articles 9A and 9B. And on the facts, the claimant's prior application for emergency arbitrator was refused by the LCIA. So that decision appears to limit the court's powers under Section 44. So the parties will need to take extra care when considering, particularly where an emergency arbitral procedure is available, and and for a detailed consideration, you really need to look and think about whether it's depending on the actual situation of the case. And you can compare that with Gig Sky APS and Vodafone. In that case, the evidence was that the appointment of an emergency arbitrator under the 2012 ICC arbitration rules would have taken about 11 days, which was found by the court to be far too long to prevent the irreparable damage to the applicant's business in the absence of interim measures under Section 44.3. So the court was persuaded that the order was urgently required to prevent the respondent from turning off the applicant's access to data roaming services, etc., which would have resulted in a rapid flight of customers from the applicant's service to their competing supplier. So you really have to look at those kind of matters. The other points, the case that I'd like to just mention is Duchen Babcock, where and this is mainly to show that the ambit, or when you're applying for interim relief in relation to assets or property, the term assets has been held to be broad enough to cover a chosen action. So in the Daman case, Dobson case, the court held that this category included contractual rights and held that the interim injunction could be granted pursuant to the Section 44.3 for the preservation of a contractual right. And in that case, to have taking over certificates issued under the FIDIC contract. And it was to that effect to preserve the value of that right. And in that case, removing the defender's ability to make demands over to on-demand performance guarantees. The other case I've just mentioned here, obviously, is the Abre versus Abre case. And in that one, it concerns a working partnership agreement where the court found that it had jurisdiction to grant interim injunction under Section 44.2e and subsection 3 as well, as the case was one of urgency, notwithstanding a pending application under Section 9 to stay the underlying court proceedings in favor of the arbitration. But the judge did conclude that the outcome of the stay will only affect the court, would not affect the court's power to grant injunctions sought under under that power that would be provided under Section 44. So you're looking at the courts, because the court has its inherent jurisdiction under Section 37 of the Senior Courts Act, as I mentioned, in order to provide anti-suit injunctions, which are not necessarily have to be dealt with under Section 44. The VX case, I think, gives a good basis for and outlines the basis for applications and grounds for court's assistance pursuant to Section 44. But time permitting, I'll just mention that, as we said, that the court's statutory power is only available to the extent that the tribunal does not have the necessary powers themselves or unable to act effectively. So what does that mean? So it could be where there's no tribunal formed, but as I mentioned, it really depends on what the situation is. Are there emergency arbitration provisions that have been agreed by the parties because they've agreed to certain institutional rules? And you'll know that a lot of the institutional rules have provisions for emergency arbitrations. The other situation could be, of course, with third parties. And as we know, that third parties, the tribunal is limited in terms of getting interim relief under third parties, where you could deal with it under the court. The other one is where there is where the tribunal's ability is curtailed. So where the parties have made a specific agreement that the tribunal shall not have the power to act in a certain circumstance, or have incorporated arbitration rules which restrict the tribunal's ability to act. Another situation could be obviously where the application is for a remedy outside the tribunal powers, is where you're looking for a freezing injunction that needs to be made without notice, and that the applicant would be justified in seeking the assistance of the court under Section 44 on the basis of the urgency of the application rendered and the powers under it. For example, the LCIA rules to appoint an emergency arbitrator under the Gerald Metals case, etc. Another situation could be the post-award relief. So the court will normally not act on the basis of Section 44 until there is since there is no arbitral proceedings in process. It cannot be said that the tribunal has no power or is unable to act effectively when it is functus officio. So Section 44.1 is clear that the court's powers are for the purposes of in relation to arbitral proceedings. So you'd have to go under the normal kind of arbitration proceedings, normal kind of injunctive proceedings in those sort of situations. The use of the word proposed in Section 44.3 suggests that the Section 44 can be applicable even when arbitral proceedings are contemplated, but the implication is that if the proceedings are completed, Section 44 may no longer apply. But in Decrease City, it does appear to be accepted and in tentative terms that a post-award freezing order may still fall within Section 44, but that is still unclear. So that's the kind of situation at the moment here under the UK stuff with regard to.
Thank you, Shobana. This is very interesting, and it's interesting to see that the courts do retain this power to examine when the choice of the parties is effective, and whether the tribunal does indeed have the powers to resolve the urgent matter. And so, yeah, that's an interesting point. We had a specific problem or a situation in Brazil in which parties had made emergency arbitrator mandatory, excluding the powers of the court, and so that always comes into that type of situation, to know how effective that choice is, because sometimes, as you pointed out, even the time for an emergency arbitrator, even being very fast, may not be fast enough.
And I think the other problem I find, Cesar, is the fact that, well, there's two advantages. One is the advantage of the court, because the English courts here, we can apply for injunction 24/7. It's possible. Yeah. I think the second issue is about the problems with enforcement of an emergency arbitrator award in different jurisdictions as well. So I think that becomes a kind of...
that's a whole other problem. Yeah, let's keep that enforcement issue for the Q&A. I know you have to leave a little earlier, but if you can stay, I think that can be a very interesting topic for later. And now we're going to travel all the way across the globe and go to China and hear from Wenny about the new China Arbitration Act. And so Wenny, if you can share with us some ideas about the China Arbitration Act. The floor is yours.
Okay, thank you, and good morning, afternoon, and evening, everyone, and thank you for having me. My name is Wenny Huang, and from the CIArb East Asia branch. Today, I and Professor Christoph Toh actually would like to talk about what is the China arbitration development, and I will walk you through the recent development in Chinese arbitration law. And in particular, I will focus on the newly revised arbitration law of People's Republic of China, which came into effect just a few days ago on the 1st of March 2026. And I will also touch on the institutional trend and foreign-related arbitration, some data that give you a broader picture of China's arbitration development. So let me briefly outline what I would like to cover. First, I will set the screen with some background on China's arbitration development. And the second, I will trace the legislative journey of the 2025 China arbitration law revision. Third, I would like to highlight the key for reform introduced by the new law. And also, I would present the latest foreign-related arbitration data from China's leading institution for the data of the 2024. And finally, I will address the remaining challenging and offer some forward-looking observation from my side. And first, to appreciate the significance of the new law, I think it is important to understand the scale of the China's arbitration market. According to the Ministry of Justice in China, China now have 285 arbitration institutions with over 60,000 panel of arbitrators, including more than 3,400 is from overseas, outside mainland China. In 2024, for the a total 4,373 foreign-related arbitration cases were handled nationwide, involving a total dispute value of around RMB 200 billion, and it is about, in US dollar, is about 27.5 billion. This number seems like to be a very, very big number, but for me, it is not enough because, well, if we are talking about the total arbitration case number in 2024 in China, it is about over 660,000. So you can see the foreign-related case only about 0.5% of the total number of the China arbitration. And so let's back to the legislative journal of the new arbitration law in China. From the very beginning, the arbitration law was first adopted in the 1994 and took effect in 1995. So you can see for the almost 30 years, it underwent only very, very small technical amendment in 2009 and 2017. The call for substantive reform grew very, very loudly as China's economic internationalized. In July 2021, the Ministry of Justice released a comprehensive draft that was widely praised for its progressive approach. It proposed removing some mandatory requirements, for example, for designating an arbitration institution, and also to kindly adapt the competence principle and empower a tribunal to grant interim measures and allow ad hoc arbitration. However, in 2024, in the draft of the 2024 submit to the NPC Study Committee in the November 2024, the draft stepped back from many of those reforms in the 2021 version and adopt a more conservative stand. So after 3 rounds of the review, the final text was adopted on the 12th September 2025 and came into force on the 1st March 2026. And the result was 96 articles across 8 chapters. The good part is the final text is a significant revision through one that has already drawn mixed reaction from the international arbitration community. So we are saying, from my view, I think the final text is one step forward compared to the 2024 version, but it's still one step back from the 2021 version. And now let me turn to the key reform of the new China arbitration law, beginning with some structural innovation. First, the concept of the state of arbitration. For the new law, it is the first time in Chinese legislation formally recognized the state of arbitration for foreign-related case. So now it's in the new law, Article 81. The seat now determines the governing proceeding laws, the court with supervision and the supporting jurisdiction, and the nationality of the ward. This is very, very important because in the previous arbitration law in 1995, the term of the seat never be touched. So this is a very, very important and a crucial development and address the long-standing unclearness and align with the international practice. And the second is the ad hoc arbitration. Article 89 of the new arbitration law introduced the ad hoc arbitration in the but in two limited categories. The first is the foreign-related maritime dispute, and the second is foreign-related dispute between the enterprise registered in the pilot free trade zone and the Hainan free trade port. While this is a cautious step, it presents a historical opening for China, which has never previously recognized ad hoc arbitration in its legislation. Of course, in practice, there are some pilot schemes for ad hoc arbitration already, but not in the legislation level. And the third is the foreign institution. Article 86 permits the foreign arbitration institution to establish their business office in pilot free trade zone and the designated area to administer the foreign-related dispute. Previously, only the representative office, for example, the ICC, SIAC, HKIAC, and also the CIArb opened their rep office in Shanghai Free Trade Zone before. But now, from the legislation level, it is very clear that the business office can be built up in China, even only in the pilot free trade zone and some designated area. And the new law also introduced several important procedural reform. For example, in the Article 31, it is partially recognized the competence principle. The parties may now submit challenge to the validity of an arbitration agreement to the arbitration tribunal, the arbitration institution, or the court. However, where different parties submit challenge to different body, the court will have the final determination. This is progress, but falls short of full tribunal autonomy as seen under the unsatural model laws. And also for the online arbitration, Article 11 expressly permits online proceedings unless parties object. This opt-out module formally affirms the virtual hearing and electronic submission carry the same legal effect as the principal counterparty. And this is also consistent with that the leading Chinese institution like CTEC has been practicing for years, with 82 of their all new filing in 2024 has already made online. And also the arbitrator disclosure and interim measures. The new law new law make it very clear about disclosure obligation to a legislation level and adopting the international recognition justiciable doubt standard. And finally, the time limit to apply to set aside an arbitral award was shortened from the 6 months to 3 months, which will help the fast of the finality. And now let me turn to the data part. According to the annual report of the 5 leading PRC institutions, a total of the 46,666 new arbitration cases were filed in 2024, with a 12% increase year on year. The total amount of dispute amount reached to the RMB 500 billion, over 550 billion, and it is about 77 billion in US dollar. But this is not the number of the foreign-related case. It is number of the total amount of dispute. And for example, also the CTAC lead in the foreign-related case with 658 cases with the foreign-related cases for CTAC. And it is about 80% increase from 2023. SDIA Shenzhen Court of International Arbitration, they handle over 500 cases. And the SHIAC, Shanghai International Arbitration Center, with over 300, and the Beijing Arbitration Center with about 283. The value of the CTAC foreign-related cases is about the RMB 81 billion, representing 43 of the total of its total case load by value. And this also this advanced significant gap remaining when compared with the international standard, and particularly with the ancestral model law. So on the progress part, the state concept has already been confirmed. The ad hoc arbitration is recognized in limited area, and the foreign institution can now operate. Partial or competence principle has been adopted. Online arbitration is expressly permitted, and the disclosure obligation have been very, very clear. But on the other hand, several key features were proposed in the 2021 draft have not made it into the final text. For example, the arbitration tribunal still cannot grant interim measures, and that is the power. The power is still with the court exclusively. So the requirements for designated arbitration institution in the arbitration agreement has been remained. So that means there are due track set aside ground inspiring and there is some distinguish between the domestic arbitration and the foreign-related arbitration. The court can still refuse enforcement of domestic arbitral award on the substantive ground, and ad hoc arbitration remains limited to the maritime and the free trade zone dispute, as I mentioned, and also emergency arbitrator is not is still in absent. So this gap leads some commentary to say the new law is one step back forward after two steps forward. So the next part, the last part, I would like to say some of my outlook and So in conclusion, I think the 2025 new arbitration law is still very, very important, and it is still one of the most significant reform to the China arbitration framework in the last 30 years. While it does not go as far as many people hopes, it does bring China meaningfully close to the international standard. And further judicial interpretation would be very important and crucial. The Supreme Court will need to issue a guideline on issues such as practical application on the seed principle, the definition of the foreign-related element, and also the interplay between the new law and the institutional rules. For cross-border users, the practical takeaway is clear. Review your dispute resolution course. Consider the implication of the seat of arbitration, choose of the institution, and whether the new ad hoc arbitration pathway may be suitable for your transaction. So here is my presentation. Thank you very much.
Thank you, Wenny. I was curious when you mentioned a very large number of foreign-related arbitrations in those 5 arbitral institutions when you're showing the statistics. Do you have any idea how many of those arbitrations are conducted in English and not in Mandarin? Or are all of them in English? I wouldn't think so, right?
I think not all of these foreign-related cases are conducted in English, but now there are more and more cases is conducted in English other than Mandarin. And because I also work for a leading China arbitration center in China previously, so I can see, for example, there is not like the percentage, but I think there is a number to say. Just wait a second. Let me see whether I have this number available. It seems like in the CTAG, actually we can read the annual report of these 5 arbitration center, and for example in the CTAG, I think there are at least they are using several working language, including the English, French as the language of the arbitration for their foreign-related cases. But sorry, I do not have the detailed number of how many cases is conducted in Mandarin, in Cantonese, or in English.
Yeah, thank you. So we will now hear from Chris To. And Chris, I understand you're going to comment also on these very exciting changes to the Chinese law, right? Thank you for being here. I think you're muted.
Okay, can you hear me now?
Yes.
Yeah.
Yes.
Thank you very much. I think Wenny has actually covered quite a lot, and given the time, I'm just going to focus on a few areas, and in particular, I'm going to actually focus on Hong Kong as well. Now, in terms of China, the arbitration law in China, I think it has been very good in terms of it gives more sort of autonomy in terms of predictability for foreign investors, especially the arbitral seats, as well as clear procedural law, as well as the supervising court for foreign-related cases. And also it follows, for example, some of the elements of the UNCITRAL model law in resolving, for example, the award ambiguities. Now, the key thing is about foreign institutions, okay? Foreign arbitral bodies can establish offices in these 3 free trade zones. Winnie mentioned about, for example, Hainan Free Trade Port, basically easing investor assurances. For example, they are credible institutions that basically they can rely on because they're familiar with those. And also she mentioned about, for example, ad hoc options to allow for certain foreign-related, maritime, as well as free trade zone cases. So that is being in the development stages to test the water to see whether, for example, ad hoc arbitration would be permissible worldwide going forward. Now, in terms of efficiencies, some people believe that some of the courts take a long time to enforce or even to set aside periods, but now they have a standard of 3 months. So you can see that is actually improved. Now, so you can see they also have the supervision of the arbitrators' independence and bias. So you can see that these are the things that they have developed over a period of time. So I'm very optimistic that the laws of China will encourage more foreign-related investors to actually invest in China and use arbitration services in China. Now, if you take Hong Kong, Hong Kong is a one country, two system. We have our own separate law. We are common law jurisdiction, whereas mainland China is a civil law jurisdiction. So if you take Hong Kong statistics, plus what Wenny mentioned in terms of those 4 organizations, I think we are the largest in terms of caseload around the world. So you can see that if you go to the Hong Kong International Arbitration Center, you can see that, for example, the number of cases has gone up year on year. But I want to emphasize one of the good things about, for example, doing arbitration in this part of the region through our centers, Hong Kong, is the interim measures. Now, Hong Kong government and also the Supreme People's Court of China actually in April the 2nd, 2019, actually came to an agreement whereby, for example, there's an arrangement for interim measures. Now, why am I saying this? Because interim measures obtained from emergency arbitrator, an arbitral tribunal, and arbitral proceedings seated outside of mainland China are not enforceable in mainland courts. But this arrangement allows parties to actually go to Hong Kong or even mainland China to do arbitrations and so forth, and to apply to the institution so that the institution can assist them in terms of these interim measures. This is a good thing. Now, in terms of Hong Kong, I want to also mention about the mediation, because I realize some of my fellow panelists mentioned about mediation. I have a heart of mediation. I really like mediation. So the Hong Kong government has implemented last year that all government contracts must go through the mediation process. That's one thing. Second is the organization that handles accreditation in Hong Kong, the Hong Kong Mediator Accreditation Association Limited, will basically establish rules and procedures to allow, for example, disciplinary procedures, codes of ethics to be tightened to ensure that, for example, things like this will be in place to protect the consumer. Now, in saying that, in September, the government hopes to actually amend the mediation ordinance in Hong Kong, our law on mediation in Hong Kong, to allow for a default appointment mechanism so that if parties cannot agree to appoint a mediator, then an organization called the Hong Kong Mediator Accreditation Association Limited will appoint. So this body is a body whereby they do most of the accreditations in Hong Kong for mediators. On top of that, the government is very keen on about promoting sports. So now we have a pilot scheme where the government will fund people if there's disputes relating to players, associations, and so forth. They are funding to assist players to go through this mediation and arbitration process. But another key thing that, for example, our moderator mentioned was adjudication. Now, last year, the government of Hong Kong introduced legislation to actually make it compulsory for people to actually must go through adjudication. So you can see that in the coming year or so, we'll see more cases in construction rather than going through arbitration or even, for example, some other forms of dispute resolution. They have no choice but to go through adjudication, which is in line with the CIArb in terms of promoting mediation, adjudication, and arbitration. So you can see that the institution is at the forefront of actually developing these role models so that the world can adopt and actually enhance our efficiency in resolving disputes. Thank you.
Thank you, Chris. It's very interesting what you said now at the end about adjudication and how that is a very important part of what CIArb does. Even if it's called Chartered Institute of Arbitrators, we have panels of mediators and adjudicators as well. And we make appointments very often of mediators and adjudicators, and it's interesting to know what you said about even this compulsory submission to adjudication in certain situations, because I'm not sure if everybody knows, and it's one of the good things about having these discussions between branches, that adjudicators from Hong Kong can apply to be, and many are, but not as many as we would like, to be on the CIArb panels of adjudicators, so that they will be available for appointments even outside Hong Kong. And so if our audience is not aware of that, please check it out. Take a look how to do that. And if you have, if you're a fellow and you have adjudication practice from Hong Kong, you can apply to be on our panels of adjudicators as well. And I do have a question for you, Chris.
Thanks, Cesar.
Since you were very you're very brief and concise on your time there, I do have a question for you. You mentioned that government contracts have to go to mediation. And what happens if mediation doesn't work? Do they go to arbitration then, or disputes are resolved in court?
Most of the government contracts involving civil works and sort of a construction and building have to go through arbitration. But some of the contracts involving procurement might have to go to court. So you can see that the government has instigated in terms of these all government contracts in a way that before you go to any means of litigation and arbitration, whether it's a procurement contract, whether it's a construction contract or renovation contract, whatsoever, you still have to go through the mediation process, whether you like it or not.
Okay, thank you. And you were going to say something about adjudication. I think I interrupted you.
Yes, I think in terms of adjudication, Cesar, I think we many of my friends who are working in law firms are very busy. It's a busy season for the lawyers in Hong Kong because they're helping clients draft lots of, for example, agreements and contracts to ensure, for example, they comply with the law so that they don't fall foul of the requirements. So they have to make sure that they have to abide by the procedures so that they will not get sort of penalized if they don't go through the adjudication process.
Mm-hmm. In about the special arrangement you mentioned between Hong Kong and mainland China, that is still something that is exclusive for Hong Kong, right? Does it apply also to Macau, for instance, or for other regions?
It does not apply to Macau. Only applies to Hong Kong and mainland China at the moment. And what happens is why has the Chinese government allowed Hong Kong to do this? It's a gift so that they encourage, for example, people have some assurance that the Hong Kong is still thriving in terms of doing international arbitration.
In a question, I don't know if maybe for you or Winnie, if I have an arbitration in Hong Kong and I get an interim measure from the arbitrators, can that be enforced in mainland China? Since, if I understood correctly, the Chinese Arbitration Act does not allow tribunals to grant interim measures and only courts. Is that enforceable in China, or would that be against, let's say, public policy and not be enforceable?
Now, Winnie she works for an organization called EBRAM, and she is one of the organizations that have been approved to assist parties. If they want interim measures, they can actually go to them, and actually then they can actually assist them in terms of making sure that these interim measures get enforced. So Winnie, you want to talk about the process of how you go about it?
Thank you, Chris. So in between the central government and the Hong Kong SAR, there is called the arrangement between the Chinese court and also the Hong Kong court on the interim measures. So the Department of Justice in Hong Kong will maybe every 2 years will have a kind of the approval process to see to see if the case is sit in Hong Kong and administered by their approved arbitration center, and such interim measures can be enforced in the China's court. So that is you can go to the DOJ's website and to have a look about the interim measures part. And then the other side, if there is interim measures from the Chinese arbitration institution, but sit in Hong Kong and would like to have the interim measures in Hong Kong court, of course, there is no problem at all. I'm not sure whether it is clear.
Maybe Maybe Cesar, to give you a better understanding, I think if you go to the Hong Kong International Arbitration Center's webpage and you look at interim measures, there is a question and answer developed by the Hong Kong International Arbitration Center, which is very clear that explains the process, what is required, and what you need to do in order to get, for example, assistance for interim measures. And that document, I think, is a few pages long. So for those who are interested, I think that document will assist them in terms of getting guidance on interim measures.
So there are some very simple preconditions. The first, the seat must be in Hong Kong, and the second, there must be administered by the currently it's 9 up to institution in Hong Kong, and the approval list is approved by the DOJ, and then you can it is very easy to apply. And from the institutional perspective, we will help the parties to send the some letters to the Chinese court, and they will grant the interim measures.
It's called a letter of acceptance.
Letter of acceptance.
That means, for example, the organizations has received it and have given it to the Chinese court, and the Chinese court will look at this letter of acceptance and say, this is from Hong Kong, and they will enforce it. And vice versa, mainland China as well.
Yeah, that's very, very good to know. Thank you so much. That has been very useful. So now let's go back to London and talk to Sue Kim about expert evidence and adjudication. And Sue is a senior director at Socotec Advisory in London, and she's a quantity surveyor, which is also not necessarily a profession that is very well known in civil law countries, but very important in common law jurisdictions and in dispute resolution in general in London. And so, Sue, if you can give us some ideas about expert evidence and adjudication, and following up from what we have been discussing about these legislative changes. Please go ahead.
Thank you, Cesar. Hi, I'm Sue Kim. Some of you may already know me, but those of you who don't, hello. My main work is working as a quantum expert witness, especially in international construction arbitration. I also practice as an adjudicator in the UK. I'm also qualified as a non-practicing barrister in England and Wales. Today, I share some thoughts, speaking firstly as an expert witness, and secondly, as an adjudicator. I'm conscious that others speaking in this branch time meeting work as lawyers, so I'll leave it to them to talk about legal issues. So firstly, expert witness. Expert evidence has become a routine feature, especially in international construction arbitration. It serves as a critical bridge between complex technical or financial matters and the legal framework of a dispute. The fundamental role of expert witnesses is to assist the tribunal in understanding these nuances. Especially for quantum experts like myself, this assistance is not only about presenting calculations, but it also involves explaining methodologies, clarifying assumptions, and providing a very clear opinion. So what do we need from an expert witness? I suggest you need 4 things from an expert witness. Firstly, expertise. Secondly, impartiality. Thirdly, awareness of different cultures and rules. Last but not least, someone good to work with. I have only about 10 minutes to speak, so I have no time to speak about all of these 4 things. But let me just say quickly. Firstly, expertise. This is something you should not take for granted. Check out the expertise of an expert before instructing them. Secondly, impartiality. This is something that is crucial. Thirdly, awareness of different cultures and rules. This is important if you wish to work internationally. Fourthly, good to work with. This is something you, again, should not take for granted. Nobody likes working with someone they don't get on with, especially in a case when they're under huge pressure. Check them out before instructing them. As I've said before, I have limited time to speak, so today I'll just focus on impartiality and awareness of different cultures and rules. So firstly, impartiality. It's probably no surprise to you that in most jurisdictions, expert witnesses are expected to be impartial. Experts should not be advocate. The days of experts acting as hired guns are now numbered. The generally accepted leading case setting up the guiding principles for expert witnesses can still be found in the judgment of Mr. Justice Grenfell, as he then was, in the Icarian River case. In this case, he listed 7 duties and responsibilities of expert witnesses in civil cases. My summary is, firstly, an expert's evidence should be independent. Secondly, an expert opinion should be unbiased and related to matters within their expertise. Thirdly, an expert should state the facts or assumptions on which their opinion is based and consider facts that might detract from that opinion. Fourthly, an expert should state when a question falls outside their expertise. Fifthly, an expert should state if insufficient data is available. Sixth, if an expert changes his or her view after exchanging report, this should be communicated to the other side and to the tribunal or court. Last but not least, where an expert refers to any document, copies must be provided when exchanging reports. There are many reported cases in England and Wales, such as Van Ord versus Dragondus, ICI versus Merrill, and Jones versus Caney, in which it was held the expert has fallen short of these necessary requirements. There are likely to be many more examples in arbitration awards, which for reasons of confidentiality remains outside of the public domain. From an international perspective, the IBA rules on the taking of evidence and the CIArb protocols for the use of party-appointed expert witnesses in international arbitration provide some good basic guidance. So, what happens if an expert fails to be impartial? In summary, it's a disaster. It's a disaster for the client because the expert evidence has been rejected, probably causing the client to lose the case. It's also a disaster for the expert. Quite apart from possibly being sued for professional negligence and reported for professional misconduct, the expert will probably never work again. Depending on the state of the arbitration, consequences can be even more serious for the expert. In some Middle Eastern jurisdictions, an expert who's found to be biased or breaches their duty of loyalty to the truth, which is imposed by the criminal laws, can also be prosecuted for giving false testimony. In other words, it might be jail time. Now moving on to awareness of different cultures and rules. This is important if you work internationally. It is important to understand where a dispute might end up and local nuances. There's no clear guidelines about how different cultures and rules deal with expert evidence. The reality on the front line is very complex. It's very easy to get things wrong and unintentionally cause conflict. Culturally, some parties prefer compulsory adjudication or Western-style court litigation, but others prefer mediation, arbitration, dispute board, or using the local court system. In international arbitration, some parties prefer pleading style and others prefer memorial style. Just to give you an example, I'm currently involved as a quantum expert with our team at Socratic Advisory in a multi-billion US dollar dispute. The main contractor engaged the several subcontractors. Rules applicable to quantum claims are inconsistent across all the different contracts, which you can imagine, which cause many problems. To give you my second example, the tribunal appointed expert is quite common in the UAE. There are some concerns about appointment process, parties' lack of control, and when parties retain their own expert, concerns about cost. My very first quantum expert appointment related to a court litigation in Abu Dhabi back in 2014, which is about 12 years ago. The tribunal appointed expert then was a civil servant working for the court without any essential expertise in construction. So within his report, he arrived at this conclusion based on his own theory without taking into account other valid opinions from party appointed experts, including myself. Right. So I'll now move on to the adjudication topic, very briefly, given the time limit available. By coincidence, I'm currently dealing with an adjudication case where I'm appointed as an adjudicator by the CIArb last week. So Christopher mentioned earlier on about the Hong Kong government made adjudication as compulsory last year. I can talk about the adjudication in the UK. So, I mean, Chris will know much more about how the adjudication in Hong Kong operates there. So, as far as I understand, adjudication in the UK and Hong Kong both provides fast-track interim binding dispute resolution to protect construction cash flows. We call it like pay now, argue later, usually within 28 to 56 days. Both jurisdictions allow for the decision to be final and binding until overturned by a later court or arbitration. So given the time limit, I'll briefly summarize 4 key differences in the UK adjudication compared to the Hong Kong. The first difference is scope of dispute. In the UK, the dispute can broadly cover almost any dispute on the construction contract. Second difference is initiation right. In the UK, either party can initiate adjudication, refer a dispute to adjudication at any time. Third difference is time limit. In the UK, decision process is usually typically 28 days, but this time limit can be extended by 14 days upon the agreement of the referring party, and also further extension by agreement of both parties. In the adjudication cases I've been involved as adjudicator, I often have a request from the both parties to extend this time limit due to the complexity of the dispute and currently in front of me at the point in time. So lastly, evolution in the UK, as some of you may be familiar with this topic, the UK since 1998, we have a very well established statutory regime. Right. These are just my brief thought in terms of the expert witness and adjudication. I hope what I've said makes sense. Please let me know if you'd like to know more about it. I'll hand over to Cesar.
Thank you, Sue. This is great. And I actually have a very objective question for you, especially since you are actively serving as an adjudicator, even through appointments from CIArb. I'm always curious to understand whether adjudicators from other common law jurisdictions, such as Hong Kong and many others, several African countries also have adjudication, and there's education in other countries with common law tradition. How easy do you think it would be for an adjudicator based in other countries to handle an adjudication that's conducted in England, like the ones that you handle from London. And to maybe add to that, should we think at CIArb, should we think about some kind of refresher course about local adjudication that we should offer to different jurisdictions or to people coming from different jurisdictions for some kind of adjustment?
Thank you, Cesar. I think your question falls into two subtopics. The first topic, if I answer first topic first, how easy it is to join the panel within the UK. So currently, I'm on the panel of adjudicated nominating bodies, about 5 or 6, including CIArb, TEXA, RSS, CIC, CEDA, and around that. So as far as I understand, when I first joined the first adjudicated nominating body that I joined was the UK Adjudicators. So when I first joined the panel, that was about 6 or 7 years ago, the criteria they imposed to everyone was whether we've done the course adjudication course, either through the RSS diploma course in adjudication or the CIArb adjudication course. As you know, the CIArb offers various adjudication courses available to anyone who's interested in practicing adjudication. So I think in terms of how easy it is to join the panel, I don't think it's down to me to answer, because whether it's easy or difficult is sort of it's kind of subjective.
Yeah, no, it was not. But I think you have already answered. But it's not really a matter of being easy to join the panel, but it being easy to handle the adjudications. Or those 4 differences that you mentioned. How difficult would they make? But let's keep that for later if we have time. I will just, thanking you again, I will just turn now to Monica. Monica is a partner at Formosa Transnational and Secretary General of the East Asia Branch Taiwan chapter. And she will tell us a little about some specificities of arbitration in Taiwan. So Monica, please, the floor is yours. Thank you for being here with us.
Okay, thank you, Cesar. So good day, everyone. It's a pleasure to be here at the CIArb Branch Time. And as we look at the evolving arbitration landscapes across the UK and Asia, you'll notice that many jurisdictions are racing to modernize. But to start things off, I want to share a very specific issue here in Taiwan that has kept our judges and practitioners very busy for years. So if you look at this slide, my topic today is a peculiarity in the Taiwan Arbitration Act regarding how we challenge awards. This isn't just a theoretical debate. It is actually the #1 priority of our current legislative reform. So let's just dive right in. So why do we even need to distinguish between domestic and foreign awards? As you can see on this slide, it boils down to 2 practical things: enforcement and remedies. So for enforcement, domestic awards act like court judgments immediately. Foreign awards, however, must go through a recognition gateway first. And for remedies, the path to challenge them is different. For a domestic award, it is setting aside, versus where a foreign award, it is refusing recognition. But here is the Taiwanese twist. In determining whether an award is domestic or foreign, our current law uses a territorial plus applicable law approach under Article 47 of Taiwan's Arbitration Act. So this means even if an award is rendered right here in Taiwan, which means the seat is Taiwan, if the award is made under foreign arbitral rules like the ICC or CIAC, we currently label it as a foreign award. And this is the root of the confusion where we are trying to fix. So now this brings us to the heart of the controversy on slide 3. The big question is, can a foreign award rendered in Taiwan be set aside by a Taiwan court? So take a look at the two conflicting views listed here. So on the one hand, the Supreme Court takes a negative view. They say no, because the law calls the award made at the seat of Taiwan under foreign arbitral rules foreign. You cannot set aside a foreign award here in Taiwan. The setting aside mechanism is exclusively reserved for domestic awards only. But on the other hand, the High Court takes a positive view. They argue that if the seat is in Taiwan, the court should have the power to oversee it. Otherwise, you end up with a remedy gap where no court in the world can set it aside. So how are we fixing this? This is exactly where our current landscape is changing. If you turn your attention to this slide, the current Taiwan Arbitration Act reform is moving to solve this ambiguity once and for all. First, some advocate to rename foreign awards to extraterritorial arbitral awards to avoid linguistic confusion. And second, and most importantly, we are now adopting a strict territorial principle. So what does this mean for practitioners? It means if your seat is in Taiwan, your award is domestic, full stop. And this ensures that the remedy for setting aside is clearly available for any award made on our soil here in Taiwan, regardless of the arbitral rules used. So to wrap everything up, let's look at the summary table. So this table shows the shift from the judicial confusion to legislative clarity. So the Supreme Court currently says no jurisdiction to set aside awards made in Taiwan under foreign arbitral awards because these awards are classified as foreign, so not applicable to for any action to set aside a foreign award. And for the High Court, it currently says yes, because setting aside may not be limited to domestic awards. And for the proposed amendment, will clarify that any award made within the territory in Taiwan is domestic, making the legal path to challenge it clear and guaranteed. So in a nutshell, Taiwan is now moving toward the international standard seen in other model law countries. This reform is the cornerstone of our effort to make Taiwan a more predictable and arbitration-friendly seat. Thank you, Cesar.
Thank you, Monica. Well, that was very, very, very instructive. And the system that we adopt in Brazil is precisely that of territory, and it does not follow the definition of internationality of the ancestral model law, but it's strictly related to territory. And so maybe that's going to be what's going to happen in Taiwan when you make that change. And just a quick question: how do you, from the Supreme Court point of view, you would have to enforce an award using the New York Convention if you consider that to be a foreign award, like an award seated at ICC in Taiwan, seated in Taiwan under ICC rules. That would be for the Supreme Court for an award, and you would have to recognize and enforce it through the New York Convention. Is that how you would do it?
Unfortunately, we're not one of the New York Convention countries, Taiwan, but yeah, the answer is yes. If the seating, well, that's exactly what the Supreme Court made in its 2021 rulings. So if the seat is in Taiwan, but the award is made under the ICC arbitral rules, then it will be recognized as a foreign arbitral award. So if you want to enforce it in Taiwan, so we have a procedure which is very similar to what is stipulated under the New York Convention. Then you need to utilize that procedure to have the award although it is made, the seat is in Taiwan, you need to have the award recognized by the court here in Taiwan in order to enforce it.
Okay. Yeah. We created that procedure in Brazil about 6 years before we joined the New York Convention. So for several years, we replicated the New York Convention solution through the national law without being a party to the convention. But thank you. That was very, very, very useful. And so now we go back to London with Glenda, and Glenda will talk to us a little about mediation, which is another thing that's a big area of concern and activity for the Chartered Institute. So Glenda, please, the floor is yours.
Hello and welcome to everybody, all our CIArb members and others who are either joining us live today or watching this later. So I'm actually in the CIArb members room. I won't turn this around too much in case I lose connection because it's not as brilliant here as it may be at home. So I've been asked, or I thought that I would talk about mediation. Now, in England, what has happened is that there has been a sea change in terms of the importance of mediation. And I'm not going to go through the past as much as where we're at now or where we have been, say, a couple of years ago. And I did produce some short notes. So if we go to 2024, in October, there were changes, amendments have been made to the civil procedure rules in England. And CPR 1.42E and CPR 3.12 and CPR 44, which deals with costs. Those are some of the important rule changes. And in relation to that, what has happened is that now a court or a judge can order mediation, or alternate dispute resolution, I should say. So in 2024, one of the cases that came before the court, and I will give the reference, it's England and Wales High Court, 2024, 3231, Chancery. And it's before Mr. Justice Miles. And it's known as the super dry case, or Asahi 100% dry and super dry. And in that case, between the claimants and defendants, the issue came up as to whether or not to go to mediation. And what was said in this commercial case was, well, we are very sophisticated parties. We don't need to be ordered to go to mediation. Now, I have put some references in relation to particular paragraphs in that case. But what was important is the judge was basically having none of it because as far as the judge was concerned, he did have the power to do this. And so in paragraph 40, there is some force in the submission of counsel for the defendant that these are commercial parties with experienced solicitors, and that if there was realistically to be a settlement, one would have expected it already to have been reached. But the argument does not do full justice to experience, which shows that bringing the parties together through mediation can overcome an entrenched reluctance of parties to negotiate, even where sincere. The purpose of mediation is to remove roadblocks to settlement. I am unable to accept the submissions of the defendant, that a mediation here has low prospects of success, and that adjudication by a court is necessarily required. The range of options available to the parties to resolve the dispute through mediation goes beyond the binary answer a court could provide. And so what then happened was that directions were made, but the reason why this caused much hilarity in England was because on the 13th of January 2025, a postscript was added to the judgment, and the judge noted this. The parties notified the court that they had settled their dispute. So we suddenly saw that in a case in the commercial court where sophisticated parties or one side thought that no, they didn't need to utilize alternate dispute resolution, that actually when ordered to, well, they actually managed to get together and resolve the dispute. Now, there has been a difference in England following the changes in the CPR rules, because in areas such as family law, there's been rule changes in the court, there have been changes to the court orders. So when it fell upon the commercial courts, or commercial parties, I should say, there was initially a reluctance. However, matters have moved on in that regard. And I want now to turn to the latest case, which has come out, which is now a little bit more nuanced. And the reference for this is 2025, England and Wales High Court, 3276. And here we have Mrs. Justice Jefford. And some of you may know that there has been ongoing litigation in England, which followed the Grenfell Tower tragedy. Now, much of the claims, or many claims in terms of personal injury, have settled. But what we have now before the courts is a dispute, or I should say litigation, between the Royal Borough of Kensington and Chelsea and Becker Polar Manufacturing and Excava UK Limited. But this particular case, what's very important here is that the judge here, they were considering mediation, alternate dispute resolution, but there was an issue over disclosure. So what has happened in this case, which is somewhat different, is that the judge didn't simply consider that, oh, yes, we'll simply order mediation now. They had to look at timing. And in terms of perhaps some of you who are dealing with disputes like this judgment will be quite interesting for you to consider. When should you have mediation? Should it be when you've had all of your disclosure? Should it be ordered before? And this is in relation to quantum. So the judge also looked at, in this case, cases where perhaps one side may think, well, we can have a mediation because we can have more than one along the way. However, as was said, and this is paragraph 18, we return to the point that all parties must participate in a mediation and participate effectively. The court and some of the parties have observed that mediation is often not a one-stop shop, and that the parties may return to ADR on more than one occasion in the course of the life of proceedings. But we consider that it is not in accordance with the overriding objective or the spirit of mediation to put the parties in the position where some are, for understandable, if to some extent overstated, reasons concerned, that they lack the information which will underlie a successful mediation, and that there is, as a result, a real risk that the costs of the mediation itself may be wasted. Now, she goes on to say, we are also have taken into account Mr. Pearce's point that a party with less deep pockets, such as her client, could quite probably not afford to participate in multiple mediations. So in this case, there's been an acknowledgement that actually it may not be cost effective. We really do have to focus on when disclosure should happen. Now, I'm going to move on now to consider, we have the Singapore Mediation Convention, and actually England and other countries may have ratified it, but it's not in force yet here. It is in force, though, in Japan and in Singapore. So I welcome comments from other speakers in relation to that. But what I would like to consider or put to you now is how exactly commercial parties or how business is viewing mediation. And I noted that Hansard, so our record of Parliament on the 16th of December of 2025, that questions were being put in relation to mediation. And I'm going to read this out because it's quite interesting. So the Minister of Legal for Courts and Legal Services said, mediation saves people time, money and stress. It can also help to reduce court delays and save the taxpayer money. Mandatory mediation for small money claims is now well integrated into the county court process and is delivering real results in terms of time savings and cost savings. Then we have Sir Julian Smith, who stated, time pressure is one of the best routes to encourage alternate dispute resolution, as the Minister knows. But in the commercial court in 2024, the median time to judgment was 786 days. The UK law sector is up against huge pressures from Singapore and the Middle East, which are offering 6 months to judgment and 6 months for appeal. May I urge ministers to look at the competitive challenges facing UK law against such tough international competition? And then Sarah Satman replies, the right honourable member raises a really good point. Such delays are depriving our businesses of productivity and the ability to resolve disputes sooner. The successes we are seeing on small money claims under £10,000, which tend to affect small and medium-sized enterprises, show the progress that can be made. The other point I will point to him to is the launch of our English Law Promotion Panel, which is looking at competitiveness with other jurisdictions. Now, I hadn't heard of this English Law Promotion Panel, and so I looked up the members of the English Law Promotion Panel, and they include none other than Jonathan Wood, Kevin Nash, Lucy Greenwood, Claire Ambrose. So all people who we are all familiar with, but they will be promoting English law in terms of resolution of disputes. So I've rattled through here to try to show where we're at, both in terms of Parliament and business and some of the case law. But as I say, I'm as interested in learning about the situation in Japan and, as can be seen, our competitors in Singapore in terms of dispute resolution. So thank you. And I hope that the notes in which will put sort of guide you or pinpoint you, or signpost you to these cases or Hansard will be made available. Thank you, Cesar. We are coming up to lunch now, and there is another speaker. So I think that's all I want to say at the moment.
Thank you, Glenda. Yeah, absolutely. The notes must be made available to the audience, and this is all very rich and useful material that will guide them guide all of us through all these very interesting topics. I will indeed turn immediately over to Douglas to tell us a little about Japan, specifically about these issues relating to mediation that Glenda mentioned. And so, Doug, please, the floor is yours. I think you are on mute, Doug.
Oh, okay. Thank you, Cesar. Yeah, thank you for putting together this very valuable program. I'm Doug Freeman. I'm a chair of CIArb Japan chapter. I'm an American arbitrator based here in Tokyo, handling mostly commercial and construction-related cases. So, this is my first attempt to create slides using AI almost instantaneously, so I cannot take responsibility for the aesthetics, but they're supposed to match Cesar's flyer for this program. But in any event, I would like to give a brief overview of recent ADR developments here in Japan. The most recent big topic in Japan is the modernization of the Arbitration Act. effective April 1st, 2024. So despite being the fourth largest economy with global businesses, Japan has been punching below its weight in terms of international arbitration, with approximately 20 annual cases venued in Tokyo under the JCAA and 20 cases under the ICC rules. But nonetheless, trading companies and other international conglomerates have been, in fact, heavy users of arbitration outside of Japan, and the cases tend to be relatively large commercial cases. Around 6 years ago, the Japanese government has finally woken up to this fact. And in April 2018, they announced the measures to strengthen Japan as a hub for international arbitration and mediation. Because of the governmental initiatives, this brought about a huge surge in interest in international arbitration in recent years in the business and legal communities. This interest culminated in the amendments to the Arbitration Act, which generally brought the act in line with the model law 2006 amendments. Japan was already a model law country, so generally you would not come across anything that is unexpected here. The highlights of this the revisions include, number one, enforcement of interim measures issued by a tribunal, which previously were not enforceable in court. Number two, it allows courts to dispense with translations of awards in enforcement proceedings, which can be a major benefit, especially when speed is of the essence in enforcing certain awards. And number three, and actually there are others, but these are just the three highlights, but the courts have consolidated jurisdiction over arbitration-related cases in the Tokyo and the Osaka district courts. So in Tokyo, this function is housed in a new Nakameguro business court, which is actually an area known for beautiful cherry blossoms in the spring, actually around this time. And my partner and the CIArb convener, Ayako, and I were invited to actually speak with the judges here at the Nakameguro court. So that really indicates this is about international arbitration, and it highlights the heightened interest on the judiciary side as well. So we are quite hopeful that Japan will continue to develop in promoting the use of arbitration in a wider sphere of businesses, including medium-sized businesses that work overseas. One of our topics is mediation. Japan was actually unexpectedly an early ratifier of the Singapore Convention in 2024, becoming the 12th to ratify, where over 50 countries have signed the convention. Japan was the 12th to ratify the convention. One thing I would like to mention, a theme as one of our themes is ADRs other than arbitration. I wanted to mention one unique feature that exists in mediation in Japan, which is it stems from judicial mediation, which is where the judge in litigation cases switches his hat and becomes a mediator to resolve the dispute. And approximately 40% or so of cases that are filed in court end up in judicial settlement that are in fact mediated by the judge himself or herself. We actually have a parallel mediation procedure under the JCAA rules, which is one of the widely used Japan-based arbitration institutional rules. Where the parties, these are mostly Japanese domestic parties who are familiar with the court process of judicial mediation, they would ask the arbitrator to serve as their mediator, switch to a mediation proceedings, and resolve the disputes without eliminating the process of having to issue an award. And in the cases that I have been involved in, this has in fact resulted in efficient and oftentimes quite agreeable resolution to the dispute. from the party's perspective. So sort of I give this out to you. I know that from common law practitioners may find it objectionable for the the arbitrator to sit as a mediator on the same case. But as I said, this in my experience, where the parties are used to this process, it often works surprisingly well with very good results. Finally, I wanted to mention CIArb initiative. One of the historical issues that Japan has had in being a lesser having a lesser interest in arbitration is the limited number of practitioners with a background in arbitration. So CIArb recently partnered with the JAA, the Japan Arbitrators Association, to co-sponsor annual CIArb courses, also with the backing of the Japanese government. So we have held introductory courses in 2022, 2023, and 2024, ARM courses in 2022 and 2023, and a fellowship course, actually the first time inaugural fellowship course in 2025, with the support from EAB, who had tutors fly over from Hong Kong to join us. All of these courses were oversubscribed, so there's really quite a great interest in CIArb courses out here. The ICC has also initiated a Japan Arbitration Day in 2024, which is continued annually around the same time. We're having one upcoming one pretty soon. And as to a part of the government initiative, we have initiated a Japan International Arbitration Week in November, which has occurred in 2024, 2025, and also this year. So it's quite well attended by practitioners from across the world. And so if you're interested in visiting Japan, November would be a great time to come. So with that, I conclude my remarks on the landscape of ADR in Japan. Thank you.
Thank you, Doug. Yeah, this is interesting. It has something to do with something that Glenda mentioned relating to this, let's say, this healthy competition between London and Singapore and other jurisdictions, and Hong Kong. I think it's interesting to see how governments become aware that ADR is not only a tool to attract investment and to resolve disputes, but it's also a business in itself. So it promotes a whole ecosystem of other services and other things that go together with it, and so it's a business to be developed, just like any other business that government can be interested in developing. And so it's good to hear that the government supports the Japan Arbitration Week. And I was a little curious when you mentioned that Tokyo and Osaka concentrate these disputes relating to arbitration. And so how does that work? If you have a dispute in any other place in Japan, you have to go to the district courts of these two places, or one of these two places?
That's a great question. In fact, they give concurrent jurisdiction to those courts. Normally you would have jurisdiction in the domicile of the respondent, for example. But this law or revision gives a concurrent jurisdiction to these courts. So oftentimes, I believe that the parties will be encouraged to sort of utilize that jurisdiction, and I think many parties would like to use that because they would like to have a judge that has familiarity with the arbitration process. That's how those cases will be consolidated in those two courts.
And so parties would simply choose either Tokyo or Osaka when they file.
Yes, I believe they will be able to choose one of those.
It's interesting. Yeah, I think there in several countries there are specialized courts, but they generally also take into consideration other usual criteria for determining which court has jurisdiction over a specific case. It's just that, let's say, in one city, there will be one court or two courts that will specialize in arbitration. And of course, as you said, it's always very good to have a judge who will understand the process and everything. But we have come to the end of our time. We have already been together here for 2 hours, which is our time limit. And I would like to thank again all our speakers and thank the enthusiasm of all the branches who joined this project of this CIArb Branch Time and came together as you have today here and to exchange these ideas about our different jurisdictions and what we have that is similar, what is not so similar, and how we can learn from each other. And before we close, I would just like to invite you to the next session. That's going to be on the 20th of April, and it will congregate Spanish-speaking jurisdictions. And so we have, within CIArb, we have several Spanish-speaking regions. Mexico is part of the North America branch. Spain is part of the European branch. Peru is part of the Brazil branch, even though it's called Brazil, it's a little brother. And so we will have these two jurisdictions and other people from different places in Latin America joining on the 20th of April. So stay tuned and check out CIArb's news, and you'll have more information in due course. Thank you again to all our speakers, to our audience, and see you next time.
Bye-bye.
Goodbye.
Thank you. Bye-bye.